I want to thank everyone for coming today to attend a conference where I'm going to talk about a very challenging and controversial executive clemency petition that was filed with the governor's office in the last months of 2005 and our resolution of this matter. It would not be the norm of our office to discuss a clemency petition in a public setting like this. It would be the norm just to simply release the decision. But because this particular matter has been one that has attracted such attention and is so complicated, I felt like it warranted some discussion, and that's why I asked folks to gather today. 4 ex-sailors who served together in the Norfolk area in the 1990s each confessed and were convicted for culpability in the rape and murder of Michelle Morbasco, who was a young Navy wife who was found dead by her husband when he returned from sea duty in July of 1997. These 4 individuals, who have been often referred to as the Norfolk 4, have petitioned the governor's office for an absolute pardon, which under Virginia law is a conclusive statement that they are innocent. The petition was filed at the end of 2005, in the last month of the Warner administration. But at the time the petition was filed, the matter was still pending in court proceedings, and it has been the longstanding policy of the governor's office not to resolve clemency petitions until court proceedings are finished. The court proceedings in this case essentially concluded in January of 2008, and so since that time, my office, working in tandem with members and staff of the parole board, has wrestled with this matter in very great detail. At my direction, interviews have been undertaken with police officers and investigators, prosecutors, defense counsel, clemency counsel, judicial officers, and the victim's family. And in addition, the sizable evidence with respect to the trials of these 4 individuals and another trial of a 5th individual have been examined in great detail. It is a complex case. It is a case where the 4 individuals assert that their confessions were false. Because there is not just a single confession, what they have asked in connection with this pardon request is for us to conclude that each and every one of the confessions that were made was false. The confessions in this case were made over an extended period of time by 4 different individuals, made to different people, made under different circumstances. Some were made in court proceedings under oath, some were made to investigators, some were made to third parties. And so necessarily the review of this matter and all of the individual confessions, and there are more than a dozen, has been complex. For reasons that I will describe, I'll take a few minutes to describe, I am denying the request for an absolute pardon. I'm denying the request because I do not believe that the petitioners have met the burden that they have of demonstrating conclusively that they are innocent of all involvement in this crime. However, for reasons I'll describe, they have raised very significant and serious doubts, grave doubts, I would say, about at least the level of their complicity in the crime. And for that reason, I am granting a conditional pardon to 3 of the individuals, Joseph Dick, Daniel Williams, and Derek Tice, who remain in prison. The 4th petitioner, Eric Wilson, was released from prison in 2005. And so I am denying his request for pardon. But the conditional pardon I grant to the other 3 will have the effect, under the terms that I have set out, of reducing their sentence essentially to time served, and they will be released under conditions into the care of the Parole Board of Virginia. A little bit about the facts of the case. And there is a 9-page statement of facts and analysis that we will distribute to those of you who want this at the end of our presentation. But the facts of the case are basically these. In July of 1997, a young, recently married Navy wife, Michelle Morbasco, who was living with her husband, Sailor Billy, in Norfolk, was murdered and raped in her apartment. Her husband, Billy, came home the next day from sea duty and found her body there and immediately contacted the police. The police in Norfolk began an investigation. The investigation centered on an individual by the name of Daniel Williams, who lived in an apartment across the hall in the same apartment complex as the Boscos. Daniel was arrested and interrogated on the first day after the murder. And in what sort of became a pattern, he protested his innocence and indicated that he was not involved with the crime. But the investigators with the Norfolk Police Department administered a lie detector test to him at some point after a number of hours of interrogation and told him he had flunked the lie detector test, that they knew he was lying, and that they then asked him to tell them the truth. After that happened, within a few hours, Danial Williams had confessed that he had committed the crime by himself. He was then arrested and charged with the crime. This pattern of the use of the lie detector test you're going to hear me repeat it with respect to the other members of these petitioners. And we have been able to look at those fairly carefully, and it is our determination that the lie detector tests were not administered in a way to guarantee any accuracy of findings, and that actually it was more of an interrogation tactic. We know you're lying, you took a lie detector test, now tell us the truth. That precipitated each of the 4 confessions that I'm about to describe. The police saw nothing in this crime when they arrested Danial Williams and interrogated him to make them believe it was a multi-perpetrator event. In their analysis of the crime scene, and then in the investigation with Danial Williams, they believed that they had the perpetrator after they made the arrest. Danial Williams had no criminal record, and he was serving honorably in the U.S. Navy at the time of the arrest. Many of the details of Danial Williams' confession were at odds with the crime scene. For example, he originally stated that he had killed the victim, Michelle Morbasco, by striking her with a shoe, but after prompting, he changed the story to suggest that he had stabbed her, which was the actual cause of death. About 6 months after Danial Williams' arrest and being charged for this crime, the forensic laboratory of the state government in Richmond concluded that DNA evidence seized from the scene, which was blood, semen, and other biological material, did not match Danial Williams. I don't know why it took 6 months, but nevertheless, that was determined in late 1997 and early 1998. At that point, the Norfolk police went to interview a roommate of Danial Williams by the name of Joseph Dick. Danial Williams and his wife Nicole were living across the hall from the victims with another sailor, Joseph Dick. The police interviewed Joseph Dick, and the pattern was somewhat the same. He indicated that he had not committed the crime. He was offered to take a lie detector test, and he willingly agreed to do so. He was told that the lie detector test showed that he was lying, and at that point he confessed that he had committed the crime together with Danial Williams. Dick had no criminal record. He was serving in the Navy honorably at the time. Many of the details of Dick's confession were at odds with Williams' statement and were at odds with circumstances of the crime scene. The forensics lab in Virginia, in Richmond, then determined that Dick's DNA did not match the DNA seized at the scene. So they placed an informant in Joseph Dick's cell who, in discussions with Joseph Dick, surfaced another name of another sailor by the name of Eric Wilson. Wilson was arrested and interrogated, and the same pattern ensued. He initially stated he was innocent. He offered to take a lie detector test. He was told that he had flunked the lie detector test. And Wilson then confessed that he had committed the crime with Dick and Williams. He also had no criminal record, and many of the bits of information contained in this confession were at odds either with the crime scene or with the circumstances of the previous 2 confessions. The forensics lab then tested Wilson's DNA, and his DNA didn't match the DNA found at the crime scene either. And so they re-interviewed Joseph Dick at this point with 3 sailors already in jail. Joseph Dick gave them 3 other names of individuals who had been involved. 2 were arrested, held for some time, but then released with no evidence was generated to suggest they were involved in the crime. But one of the names that Joseph Dick gave to the police involved the 4th member of the Norfolk 4, a former sailor, 28 years old, who was living then in Florida by the name of Tice. Tice was contacted by the police, agreed voluntarily to return to Virginia to participate in the investigation into this crime, which was now a crime that had occurred about a year and a half before. He was interrogated, and much as the previous 4 maintained his innocence, was voluntarily agreed to take a lie detector test, was told he had failed it, and he then confessed that he had committed the crime with the first 3 sailors who had been arrested and with 2 other individuals. Many of the statements in Tice's confession were at odds with the crime scene and were at odds with the statements of the previous defendants. The other individuals mentioned by Tice were arrested, But all of their DNA was tested, and none of their DNA matched the DNA that had been seized from the crime scene. So by late summer of 1998, a year after the crime had been committed, there were 7 sailors or former sailors in jail in Norfolk, all arrested for a crime. None of them matched the DNA that had been retained from the scene. 4 of them had confessed to the crime, although the confessions were at odds with each other. And at this point, the investigation kind of languished without anyone having DNA that matched the DNA that had been found at the crime scene. In February of 1999, a woman living in the Norfolk area brought a letter to the Norfolk Police Department. It was a letter from a prisoner who had been imprisoned at the Augusta prison in Western Virginia, and a man by the name of Omer Ballard. And in this letter, Omer Ballard had written it to threaten a former girlfriend. And in one of the last lines of the letter, in threatening her, he said, if you don't do what I want, and this is a paraphrase, I'll do to you what I did to Michelle. The mother who received the letter to the daughter recognized this as a reference to the murder of Michelle Bosco and brought it to the Norfolk Police Department in February of 1999. This was now nearly 15 or 16 months after the murder. Omer Ballard was in prison in Augusta for 2 crimes that had been committed within a month of the Michelle Bosco murder in the same neighborhood where she had been murdered. About 2 weeks before Michelle Bosco's murder, Omer Ballard and another individual had attacked a woman with a baseball bat in the same apartment complex where Michelle Bosco lived. He was being then chased by a group of the apartment residents and managed to take refuge in the Bosco's apartment. And the Bosco sheltered him from the group of residents that were trying to attack him for this attack that he had committed. He was ultimately convicted of that assault with the baseball bat. About 2 weeks after the Bosco murder, Ballard committed a rape at knife point, strangled and raped a 14-year-old girl within a mile of the apartment complex, and was convicted and imprisoned for that crime. So he was serving time in Augusta at the time police found their way to him for 2 very violent crimes against women committed at the same time in the same neighborhood as the Bosco apartment. When the police visited Omer Ballard in Augusta, he refused to talk to them and answer any questions, but he did agree to allow physical specimens to be taken to do a DNA test. And the test immediately showed that his DNA matched the blood, the semen, and the other biological material that had been found at the crime scene. When this was discovered, the police returned to Augusta and interrogated Omer Ballard. He immediately disclosed that he had been the one who had killed Michelle Bosco. He said he had killed her by himself, and his confession was accurate, including accurate about some very minor details of the crime scene that had not been in newspapers and that none of the other defendants had been aware of or had been mentioned in their confessions. Ballard pled guilty to murder. He was convicted and sentenced to life imprisonment. In the statement that he signed prior to the plea in about February of 2000, he changed the story that he had committed the crime on his own and indicated that he had committed the crime with the 4 sailors and that he had been hiding the fact of their involvement for various reasons, for an irrelevant reason. But that was his confession and the plea statement that then was used at the time that he was sentenced. Ballard has since maintained that he only changed his story to implicate the other sailors because he was told that if he did so, he would receive more favorable sentencing treatment. But those that were involved, the investigators and others on this case, deny that that is the case. Those are the basic facts of this case. Let me now talk about the trials and what happened. Obviously, each of these 4 individuals, the Norfolk 4 petitioners, confessed, and in some instances confessed in multiple instances to involvement in this case. There was evidence that Daniel Williams did have an unhealthy obsession with Michelle Bosco, evidence from at least a couple of independent sources. During the interrogation of at least 2 of the petitioners, Derek Tice and Joseph Digg, They both indicated at some point in their multiple interrogations that they had committed this crime with an unnamed black male that generally would have met Omar Ballard's description. The first of the 4 Norfolk petitioners to go to court was Danial Williams. Daniel Williams had pled guilty to the crime, had both initially in the interrogation confessed, but he had also pled guilty to the crime and signed a stipulation as to his involvement in the crime. At the time of that signature, he knew that the DNA evidence that had been found did not match his DNA evidence, but he nevertheless signed a confession to the crime and a stipulation. He made an attempt to withdraw his plea of guilty in the trial court in Norfolk after Ballard was arrested and there was a conclusive DNA match with Ballard. The trial court turned that down. He was sentenced to life in prison. Joseph Dick pled guilty after Ballard's culpability in the crime became known. He pled guilty. He signed a stipulation as to his guilt. He was asked in open court why he was pleading guilty, and he indicated he was pleading guilty because his conscience had gotten the better of him and he needed to come clean with his conscience. At his sentencing, which happened now many months after Ballard had been arrested, Joseph Dick tearfully apologized to members of the family in open court for his role in the crime. Dick had also written at least one letter to a third party that was never mailed while he was in jail, in which he admitted to the culpability to being a participant in this crime. Eric Wilson went to trial, did not plead guilty, but pled not guilty. And he went to trial in a jury trial in the Norfolk area in late 2000. His confession was played in court, but they were able to put on significant evidence about Ballard's culpability, the lack of any DNA match with Eric Wilson. Eric Wilson also took the stand and told the jury that he had falsely confessed, and he and his counsel pointed out that there was no physical evidence whatsoever tying Eric Wilson to the scene. The jury in the Wilson case sentenced Eric Wilson, convicted him only of rape, not murder, and sentenced him to 8.5 years in prison. Eric Wilson was released from the Department of Corrections in 2005. The final petitioner in the Norfolk 4, Derek Tice, had a complex trial history, if this wasn't complicated enough. His trial was moved to Arlington because by the time he was tried last, there had been so much publicity about this case in the Norfolk area that there was a concern about finding a juror that didn't have pre-existing opinions about the case. And so he was tried in Arlington. He had very able trial counsel, Tice did, who put on a lot of evidence about Ballard's confession, about Ballard being the only one with any physical evidence tying him to the scene. Tice's confession included individuals in the confession who were conclusively proven not to have committed this crime. They had airtight alibis. The defense counsel pointed that out. The defense counsel put on expertise to show that the circumstances of the crime scene were inconsistent with a multi-perpetrator attack and were only consistent with an attack by a single perpetrator, in this case Omar Ballard. Tice did not take the stand. The confession, an 18-minute confession, was a very chilling confession. One phrase of the confession that was, I think, particularly graphic for the jury was a statement of Derek Tice's that I told Daniel just to stab the bitch. That was played in open court, and Derek Tice had an opportunity to take the stand to rebut that, but chose not to. He was found guilty by that jury of capital murder and rape. The Virginia Supreme Court overturned that verdict on issues dealing with both an evidentiary matter and a jury instruction. And so he was tried a second time in Northern Virginia, I think in Alexandria. I can't remember if it was Arlington first or Alexandria or vice versa, but nevertheless he was tried a second time in Northern Virginia. And the second trial went very much like the first. He was not charged for capital murder in this instance, only non-capital murder, but the trial was basically the same. The same kinds of evidence was introduced. Omar Ballard was called as a witness in both trials, but refused to talk at all, give any meaningful answers to questions. But once again, the Tice confession was played, and Derek Tice chose not to take the stand. The defense was essentially that the confession was false, but he did not testify as to that. The jury found Tice guilty of non-capital murder and rape, and that was the last of these trials. Two of the individuals who took their case to trial, Eric Wilson and Derek Tice, have appealed in state and federal courts, but the appeals have been unavailing. So now we get to the decision, and I've highlighted what I have done at the start, but let me now get into it. Again, an absolute pardon is a request that the governor make a conclusive declaration of innocence in any and all involvement in this crime. Unlike a trial where an individual is often trying to demonstrate reasonable doubt, showing reasonable doubt or even grave doubt is not enough. An individual to get an absolute pardon has to demonstrate conclusively that they were innocent of the crime. I think these individuals have demonstrated grave doubts, but I don't think they have conclusively demonstrated their innocence. Let me begin with the grave doubts that they have shown. All of these individuals were law-abiding citizens with no criminal record. All of them were serving honorably in the U.S. Navy at the time of the event. All of them were convicted primarily based on confessions. Confessions that varied from each other, confessions that varied from the crime scene, even in important particulars, such as who was involved in the crime. None of the initial confessions mentioned Omar Ballard or any blackmail, and many of the initial confessions mentioned other individuals who were conclusively proven not to have been involved in this crime. There is no physical evidence, including no DNA, but no physical evidence of any kind tying any of the four petitioners to the crime scene. Most especially Omar Ballard, there is airtight evidence, both physical and testimonial, that establishes that he was the perpetrator of this very, very grim crime. And so in those circumstances, the petitioners have raised very serious doubts about their complicity or about their level of complicity. However, as I have wrestled with the issue of more than a dozen confessions given in different times, in different places, to different people, some in custodial and interrogatory situations, but some in letters to third persons, I find, just as I believe the jury and judge found in this case, that it is difficult to completely ignore the entire weight of these confessions. It is difficult to completely ignore Joseph Dick's repeated confessions and his tearful apology to the victim's family in the courtroom that sentenced Eric Wilson and that sentenced, in the courtroom that sentenced him. His testimony in the Tice and Wilson trials and his tearful apology in his own sentencing, as well as other statements to third parties, his statement that I needed to do this to clear my conscience, is difficult to completely ignore. Similarly, I believe the trial jurors in this case had a very hard time completely ignoring the Wilson recorded confession and the Derek Tice confession, both of which I've listened to. They're audio-taped confessions. These are lengthy and detailed confessions that are very stark and difficult. They're a little bit, makes you sick to your stomach to hear them. It is the case that when you listen to both of them together, there are some aspects of them that make them sound as if they're describing completely different events, but these are very, very difficult confessions. I also think that it is for purposes of the pardon. This would not be the case for purposes of the trial, but for purposes of the pardon, I think it is a notable fact that Derek Tice had two opportunities to sit before a jury and tell them that he did not commit this crime and that his confessions were false. And instead, he chose not to. The fact that he chose not to talk about the fact that the confessions were false was a decision that he was entitled to make in the course of the trial. But for purposes of wrestling with this in the aftermath and asking myself, and I'm the only one who can make this decision, about whether he has conclusively demonstrated his innocence, the failure to testify, and frankly our discussions with many surrounding the trials about the reason for that, are things that I think are matters that are worth some consideration. In addition, there are at least a couple of facts out there. It's not just the confessions, at least a couple of facts out there that suggest that there could in fact have been some level of involvement by these individuals in the crime. For example, there is solid independent evidence about the pre-existing fixation that Daniel Williams had on Michelle Morbosco that was mentioned in a number of the confessions and also mentioned by third-party witnesses. And it is the case also that both Derek Tice and Joe Dick, in their discussions with investigators about this crime, acknowledged at one point that they had committed this crime with an unnamed black male who generally matched Omar Ballard's description. So this is what is so challenging about the case. There are many, many aspects of the case that are troubling, and I would say that these individuals have raised serious doubt about their involvement or about the level of their involvement. But I do not believe that they have conclusively demonstrated that there is no possibility that they were involved in this crime. And since they have not made that conclusive demonstration, I have decided to reject their request for an absolute pardon. I do have another power under the executive clemency powers as governor, and that's to grant a conditional pardon. And a conditional pardon is a broad power, and in this instance, I am going to use it to essentially reduce the sentences of Derek Tice, Joe Dick, and Daniel Williams to time served. They have now served in prison since essentially 1997. It's 1998 in Dick's case. I think I am the only person now who has looked at all the evidence. Each of the jurors and judges looked at the evidence about one of the cases, but they didn't have all 4 cases. They didn't have all 5 cases before them. I do have all 5 cases before me, and I have looked not only at the confessions and the evidence, but I've looked at other information that we have been able to determine through the interviews that I mentioned earlier. I think what the petitioners have demonstrated, even though they have not conclusively demonstrated their innocence, they have demonstrated that any involvement in this crime was at best of a significantly lesser magnitude than Omar Ballard. The one jury that heard from a petitioner who said the confessions were false, and I didn't do this, Eric Wilson, essentially reached the same conclusion when they sentenced Wilson to an 8.5-year prison sentence. They gave the other individual's life. And as I wrestle with all the circumstances of these 5 cases, I am just struck by the fact that I believe that the 3 petitioners are much more equivalent in their culpability level, recognizing and wrestling with all the doubts. They're much more equivalent to Eric Wilson than they are to Omar Ballard. Ballard was the primary perpetrator of this crime, was the person who is most responsible for this crime, and it is appropriate that he be in prison for the rest of his life. But these other 3 petitioners are much more similar in culpability, if any, to the culpability of Eric Wilson. And so for that reason, I have decided to grant a conditional pardon to Joseph Dick, Daniel Williams, and Derek Tice. The terms of the conditional pardon will be available, but essentially they will be remanded into the custody for a number of years of the Virginia Parole Board. They will be released from prison if they choose to accept the conditions. But the Virginia Parole Board will then manage them if they choose to accept the conditions upon their release. Let me say one other thing, and I'll open it up and take a few questions. Obviously, one of the issues that has been kind of big picture that has been a challenging one about this from the beginning is the issue of the confessions. We could not really find another case anywhere where there was an effort to set aside so many different confessions. Again, if this was a case where there was a single false confession, was it true or false, that would be one thing. But this was a case, again, in which there were over a dozen confessions given in different circumstances and different times to different people. And the fact of the confessions themselves and their validity obviously was at the very core of our wrestling with this matter. Since the Norfolk 4 trial, the Norfolk Police Department and investigators have adopted a very laudatory practice, which is to audio or videotape confessions. If there had been a complete audio or videotape record of these confessions, instead of just an audio tape of sort of the last confession, when it was kind of in the position, and that was the one that would play at trial, I think we would be able to delve into this in a lot more detail, and frankly, it wouldn't have probably taken us so long to work our way through this. I have no way of knowing whether the Norfolk Police Department embraced audio and videotaping confessions because of this case. And I haven't asked them whether that was the case. But what I do know is this. That practice in Norfolk has been a practice that the law enforcement community there has embraced and feels has been very, very helpful. Another case recently was decided in Virginia. It was a case in the Virginia Supreme Court dealing with an inmate who had been convicted of capital murder by the name of Atkins. I can't remember the individual's first name. But a somewhat notorious case that had been in the U.S. Supreme Court a couple of times. The Circuit Court of Virginia and the Virginia Supreme Court within the last year granted Atkins relief from his capital sentence because it was determined that the confession that was played at trial, that was a critical piece of evidence in this trial, was essentially kind of a doctored confession, meaning it was a confession of a co-defendant. The investigators in the case had started the tape, but then every time the co-defendant said something they didn't like, they would stop the tape and then they would coach it, and then they would start it again, and they would go back and forth with the confession. When that was revealed, that there had been a 16-minute gap in this particular tape while this critical witness had been coached, the courts of Virginia determined that Atkins had been unfairly tried and granted him habeas corpus relief and relieved him from his death sentence. And so one of the issues that I think is a broader point from this case is the fact that any confession could potentially be unreliable. Most confessions that have reliability challenges or confessions of youngsters are those with severe or with mental impairments, which would not apply to at least 3 of the petitioners in this case. But you can make a confession an awful lot more reliable if you use audio taping and videotape. As we've wrestled with this aspect of the petitioner's clemency petition, I'm very pleased to just acknowledge some very good work that's been done by Colonel Steve Flaherty with the State Police and by John Marshall, our Secretary of Public Safety, who's a former state trooper. Beginning in August of 2008, in a new protocol, the State Police has adopted a policy where it is the norm now for all confessions that are received in any state police office, basically, in any custodial setting, to be audio taped and videotaped. From the very moment anyone walks in the room to the end of the last statement that is made, so that a full record of the confession can be had both to help the prosecution but also to help the defense, so that all can be aware of the circumstances of the confession. That bit of legal change with respect to Virginia State Police policy is a very laudatory one. It's been in place since August, and I think the State Police in Virginia believe that it has been working quite well. The audio and videotape equipment used by the State Police to do this are also available for local governments, and some are availing themselves of it. That will be a subject for another day, but definitely full audio or videotape records of confessions are something that should now be the norm in any investigation of a significant crime in any custodial setting. But I'll just conclude and say this has been a very challenging matter. Many believe that, well, hey, how come it's taken so long to try to decide it quickly? But we wanted to get this right. And it was a case really like no other we had seen in literature, where there were so many confessions that were asked to be ignored. Having thought an awful lot about this since January of 2008 when the court proceedings are done, I feel confident that we have gotten it right. The primary perpetrator is in prison for the rest of his life. These 3 petitioners have shown doubts about their conviction, but have not conclusively erased their chances of involvement, yet they have demonstrated that any level of complicity was in a more minor way than the primary perpetrator, and for that reason we believe the conditional pardon is appropriate. With that, I'd be glad to open up and take questions.